Our next case is Safeco Insurance Company versus Raider. Are both sides ready?
Yes, Your Honor.
Yes, Your Honor.
Helen may proceed.
Thank you. Good morning, and police court. My name is Richard Young, and I represent Safeco. I'd like to reserve 4 minutes for rebuttal, please. Your Honor, there are 2 errors committed by the trial court in this matter. The first error is a failure to enter final judgment on the UM claim after Safeco confessed judgment, and then thereafter allowing an amendment to the underlying complaint to bring a bad faith claim by the plaintiff. The second error is the court allowed the plaintiff to present the testimony of an alleged expert witness, Michael Hook, in the area of bad faith, when Mr. Hook lacked the appropriate qualifications to testify. Safeco requests reversal of this matter on both grounds. As to the first issue, there's a case that we pointed out in our brief called Safeco versus Friedman. It's currently on appeal to the Florida Supreme Court. It's already been briefed. It's been argued. I believe that was last April of 2015, and it is waiting on resolution. It will resolve, we believe, the procedural matter in which you handle this type of situation. But we believe that this case should be reversed regardless of what happens in the Friedman matter, because Friedman is going to resolve a question of 2 different ways that you approach this scenario. You have a UM claim in the underlying matter, and you have to decide, do we try the damages in that UM claim, and that's the measure of damages to bad faith, or do you enter final judgment for the policy limits, and then you have a trial for bad faith damages. Now, Safeco versus Friedman says you do it the second way. Patton is a case out of the 4th DCA that says you do it the first way, meaning you go ahead and continue with the UM claim, but not the bad faith claim, and come to a determination of damages. We believe the Florida Supreme Court will probably resolve which one's appropriate.
Now, in Friedman, though, didn't the court enter a final judgment and then try to reserve jurisdiction on the bad faith claim, whereas here we have a partial judgment. We don't have, it's a little bit distinguishable in that regard, isn't it?
Well, in Friedman, Your Honor, actually what happened was the court refused to enter the final judgment and proceeded ahead to a jury trial on the UM damages in the UM claim. Bad faith claim was not brought at that time. Safeco appealed and said you didn't have jurisdiction to do that. Once we tendered our policy limits and confessed to judgment on the UM claim, your jurisdiction ended. The only thing you could do at that point was enter final judgment in favor of Safeco and close the case.
Okay, help me here, though. Seems to me, if I understand your position, after the final judgment we would have been entered in this case, they would have had the right to bring a separate action for bad faith.
That's correct, Your Honor.
I'm really having trouble understanding the prejudice to you by what the trial court did here. Why require them to file an entire separate action versus what happened here?
That is a very good question, Judge, and it goes right to the heart of why we're all dealing with these issues: federal jurisdiction and removal. The plaintiff's bar, sometime back, started bringing bad faith claims attached to the underlying tort suit, or in this case, UM claim, in an effort to get past the 1-year removal period provided for under the federal removal statute. Because if it pins for more than a year, you couldn't remove. Now, we know they've changed that now to say unless there's bad faith in the joiner, if you will. But that's why they bring them. These bad faith claims aren't right. They're not ready for adjudication. They don't exist yet, but they bring them anyway. So when they bring these things like this, the whole idea is to create this scenario where a trial judge creates this hybrid remedy where he hangs on to the UM claim and it never becomes a finalized UM claim, and therefore the bad faith claim is not filed as a separate action. It's not removable.
But in this case, in light of Safeco's confession judgment on the UM claim, Safeco wasn't required to concurrently try the UM claim and the bad faith claim. So I go back to Judge Wolf's question, how is there any prejudice here?
Well, I think we were, because the judge did not enter final judgment on the UM claim. I understand that you could say, well, what's the practical difference? But this is a procedural issue. The court had to enter final judgment. Had it done that, the bad faith claim would have been separately filed and therefore separately removable. In fact, we tried to remove this action.
Okay, let me cut through the chase. As I understand your answer is, the only prejudice you're saying that your client suffered was you couldn't remove this to federal court. And I'm not saying that's insignificant, but I just want to make sure I understand.
That is the primary prejudice that my client suffered.
Is there any
loss.
other? You said primary. Is there any other?
Well, the other prejudice, Judge, would be that I believe at this point it is still an undecided issue of law as to when you follow the, what I'll call the Friedman doctrine, and you try these things together, do you try the damages simultaneously with the bad faith? Or do you try the damages in one trial and the bad faith in another trial in front of two separate juries? That's another open issue. The court here declared we were going to try them as one. And I understand my opponent asserts that we agreed to that. We did not agree to that. That was something that the judge ordered, and we were simply asked, is that your understanding of what's been ordered? And the answer was yes, that's our understanding of what's been ordered. We're going to try them together. Now, I've actually done that before in the King case. I tried the two together. I'm not saying it's the best way to do things. And in this case, I believe it was very prejudicial to my client to be required to try them both together like that.
Why?
Why was it prejudicial? Because at the same time the jury was hearing the plaintiff's damages, they were hearing allegations of wrongful claims handling. And so I think that could very, very heavily influence their determination on damages, because they're hearing not only is a person hurt, but his insurance company's bad. So I think that the actions of the court and the way that it fashioned this remedy and the way that it created this completely unprecedented remedy. I've never seen a partial, non-final judgment. I don't think they exist in the law. I found no case that authorizes something like this. And this was done solely so the lower court could hang on to jurisdiction of the bad faith claim and prevent removal to federal court. And whether removal is something that is something that we agree with or not, it's a right, and it's a substantive right. In fact, in the Hartley case, the 4th DCA considered it such a substantive right, it accepted certiorari jurisdiction and said, the harm is irreparable if you prevent this party from exercising that right. Because later, they might not have the ability to remove. You know, that leaves the question open here. Obviously, if the court reverses this and it goes back down and the bad faith case is required to be filed separately, we probably will attempt to remove it, but I can't tell you what will happen. It's been well over a year since the removal statute has expired. So what we believe should have happened here is the court should have entered final judgment and then should have proceeded to the bad faith claim, but it didn't do that. At a very minimum, and this is why I say it should have been reversed, this case should be reversed, the court didn't even follow patent. It didn't even say, okay, well, I'm not going to enter judgment on your UM claim because you only confessed the judgment for the policy. Let's go ahead and try your full damages, get that number, and then we'll move on to the bad faith case. That's the patent theory of how we approach it. The court here didn't do either one. It picked something that is not recognized by any court. And the problem with the partial, non-final judgment is, the question is, well, did you end the UM claim? Well, not if you have a non-final judgment. In fact, we brought this matter before the court's attention and appealed this previously when the judgment was initially entered, and we're told, we don't have jurisdiction. This is not final. It's not an appealable judgment. And we understand that. But that's the conundrum the trial court put us in by fashioning this completely inappropriate remedy. So we ask that this matter be reversed on those grounds. We also don't believe the amendment should have been allowed. Now, there's been some argument or attempt here to distinguish this case from prison by saying, well, the pleadings weren't closed here. That's absolutely not correct. The pleadings were closed here. The next statement was, because there was a complaint and an answer. Then the next statement was, well, there was a pending motion for leave to amend, and the pleadings can't be closed. You can't enter judgment on the pleadings with a motion for leave to amend. And a case was cited to. That case dealt with a totally different scenario. Dealt with a scenario where a party was taking advantage of a defect in the pleadings to move for judgment on the pleadings based on the defect, and the party who was pleading said, give me a chance to correct the defect. That's not what we're dealing with here. This is not moving for judgment on a defect. It was moving for judgment on the claim because we were confessing to the very remedy requested in the complaint. Moreover, a motion for leave to amend does not reopen pleadings. It just doesn't. It's of no consequence until it's ruled upon. So the pleadings here was definitely closed. The court had the power to do this. Now, if I may, I'm going to move on quickly to Mr. Hook. The plaintiff presented an expert named Michael Hook. There's no question Mr. Hook has had some experience in the area of personal injury law. But the problem with Mr. Hook's experience is it's not in anything pertinent to bad faith. Mr. Hook has never held an insurance adjusting license, never been employed of an insurance company, never worked in the insurance industry aside from being retained as fee counsel, never participated in the formulation of any claims handling guidelines, never participated in the formulation of claims handling guidelines for any specific insurance company, never been retained as a consultant or an expert by any insurance company, never been retained as a consultant in a bad faith case before this particular one, never been retained as a consultant on any matter other than attorney's fees for that matter, never represented an insurance company in a bad faith claim, never tried a bad faith case, and other than one case he believes might have been 20 years earlier, had never even been counsel of record in a case involving bad faith. So Mr. Hook said that he was qualified to render opinions on bad faith based on his years of working as a personal injury defense lawyer. We filed a case called Lopez versus Allstate, which is an opinion out of the Southern District, because we thought it would be helpful to this issue because it goes right to the same thing. There was an expert named Katie that was being posited, in fact, by a defense, by an insurance company, and they said that his 36 years of experience as an attorney providing legal advice to insurance companies gave him the ability to testify as a bad faith expert. And the court said, no, it doesn't. Having general knowledge of representing insurers in insured claims does not make you an expert in another field entirely like bad faith. They noted he had never published articles or books on the subjects, neither did Mr. Hook. They noted he had no experience in adjusting claims for insurance companies, neither did Mr. Hook. They noted that he'd never been employed by an insurance company, neither did Mr. Hook. And never even... Yes, thank you, Your Honor. In short, we would submit that this case should be reversed on both grounds. First, that the court erred in the way it procedurally handled this matter, and secondly, that it should not have allowed Mr. Hook to testify when he clearly lacked the proper credentials. Thank you.
May it please the court, Louis Rosenblum for the appellate, along with Bill Baker, seated at the council's table. The first comment I want to make about the bad faith issue is the court has already decided every one of the issues that's been raised today. Now, I admit it was an assert petition, and it was probably dicta because what the court in Raider 1 did, it first determined there was no irreparable harm. And then second is that even though, they could have stopped it there and said cert denied, but they went on to say, we also find that the court did not depart from the essential requirements of law. So since they didn't have to write, it's probably dicta, certainly not law of the case. But what SAPO's asking this court to do is completely undo everything Judge Thomas wrote in Raider 1. Every issue has been discussed and decided. So I would respectfully submit that even though Raider 1 may not be binding as law of the case, it's certainly persuasive and it can't be ignored. And I think the court would be in a pretty unusual situation to undo it. But besides that, everything that Judge Thomas wrote in Raider 1 is correct. And let me start first with the Friedman case. First of all, I don't know what the Supreme Court will do in Friedman. They could resolve all of these problems, or it could resolve just the issue in Friedman, which is clearly different, because there, as the court has already noted, and as Judge Thomas noted in his first opinion, the court in Friedman entered a final judgment and then reserved to handle a bad faith case that had never even been filed. So that's completely different from this situation. What we have here is a case where the uninsured motorist claim and the bad faith claim are joined in one action, and the court, in its discretion, abated, although it didn't really have to because of the confession, abated the bad faith case until the UM case was resolved. Now,
And that actually gets to my question is, when we asked the appellant about prejudice, but would Mr. Rader have suffered any prejudice if the trial court had entered a final judgment and then Rader, pursued a separate bad faith claim?
Well, he would have been forced to litigate two cases instead of one. I guess that's prejudice. Of course, as Mr. Young points out, the insurance companies want to remove all of these cases to federal court. The plaintiff doesn't want it removed. And let's be real honest, the federal court is not as friendly a forum as our state courts in these diversity cases.
So in terms of the prejudice here, that the greatest prejudice is the right not to be removed.
Well, as Judge Thomas pointed out in his opinion in Raider 1, the reason the federal court remanded petition, it was untimely. So that's not going to change. So, SACO had the right to remove this case from the very beginning. When it was a UM case, it was a suit involving citizens from different states, and the mountain controversy was there. They could have removed it then, but chose not to do so. The second thing that they said prejudiced them was trying the bad faith and the damages in the same trial. And Mr. Young said, well, we didn't agree to that. The court ordered that. But let me cite to the court page 2613 and 2614. I believe this is the transcript of the pretrial conference, and this is in the supplemental record. And Mr. Baker, who represented Mr. Rader, said, it's my understanding we're going to try the bad faith issues and damages issues all in one trial as relative to, value of the case and the bad faith. That's where we're at. The court said, okay. Then Mr. Baker said, so it won't be bifurcated, and is that agreed to by the defendant as the procedure we should follow? And Mr. Palmer, who was speaking for Safeco, said, yes, sir. So they did agree to try these together. And this is not like the Payton case. The Payton case tried damages first because there was no confession there. There was no agreement as to the insured's damages in the UM case. So they tried that first, and then they tried the bad faith case, and the big issue on appeal in Payton was whether the jury's verdict was admissible. That's not an issue here.
So your point essentially is that these types of cases, a UM case and a bad faith case, can be tried concurrently, and the remedy is to seek bifurcation.
Yes, what the courts have been doing, and all of these cases are cited in our brief, and they're cited in Raider 1. What the courts have been doing is when the bad faith claim is filed, the court has the discretion to either abate or dismiss without prejudice. Now, Safeco argues that dismissal is the trend, and they cite a federal district court order for that proposition. We cited one that said just the opposite, and that's the other thing, too. The briefs on both sides in this case are littered with these federal district court orders. And just because they appear on Westlaw doesn't give them any precedential value whatsoever. They're just trial court orders, and they're all over the place. You get different rulings within the same federal district, depending on which judge you draw. And they treat this removal issue differently, too. So I don't know if they're much authority for anything.
And that goes to my second question. I mean, if we really look at the statute, there's no prohibition or authorization for concurrently trying these cases.
I don't think it addresses it at all. And when you say concurrently, it's not like you're trying the underlying, we're not talking about trying the automobile accident case with the bad faith case. What we did here is we tried the damages sustained by Mr. Rader with the bad faith by agreement, as I just noted. But the statute, and we're talking about section 627.72710, basically states, and I'm going to paraphrase it, is that the full measure of damages in a first-party bad faith case is whatever the damages would have been caused by the tortfeasor. So there's no difference between the damages the insured sustained in the accident and the damages the insured sustained by virtue of the bad faith. So they're the same. So there's no prejudice here. This was not a case where, sometimes there's prejudice caused to the insurance company because of discovery. You obviously don't want to start discovery until the UM case is over. Then it's discovery in the bad faith case. That wasn't an issue here because by this confession of judgment or agreement that the case was valued at the policy limit, the UM part was over. So discovery was proceeded, and there was an argument about that in the trial court. Safeco never appealed that ruling. Now, the other issue that I do want to address on bad faith is whether the pleadings were closed. And again, this is an issue that was addressed in Raider 1, and the pleadings were closed. I mean, you can't close a case when the plaintiff has a motion for leave to amend the complaint pending. I know of no authority to do that, and in fact, we cited a case in our brief called J&C Enterprises. There's not a lot of law on this, but we cited a case called J&C Enterprises from the 3rd DCA, and it's only 2 sentences, if I could read it, because it's right on point. It says, this is an appeal from a judgment on the pleadings in the contract case. Because appellant was not allowed leave to amend his pleadings, even though it requested, we reversed the judgment and remanded for an order permitting the repleading of the case. So that's exactly what we had here. Had the court entered a final judgment, we would have appealed it, saying you can't enter a final judgment or a judgment on the pleadings when the pleadings are still open, so it would have been reversed. Now let me move on to Mr. Hook and his qualifications. And let me preface my remarks saying, again, the federal district courts are all over the place on this. We cited 2 or 3 cases in our brief where federal district court judges have allowed an attorney to testify as expert witnesses in bad faith cases. And then Safeco filed this Lopez case, this supplemental authority, which went the other way. Again, it depends on what judge you get. But let me make this point very clear about those cases. The abuse of discretion standard will apply when those cases go up on appeal. And I suspect, which we'll never know, I suspect whichever way the judge ruled, it's going to be affirmed because it's a discretionary decision. So had the judge in Lopez admitted the testimony, that probably would have been affirmed, and if he excluded it, it probably would have been affirmed.
Well, clearly this witness could value the claim. But I guess the argument they're making is just the value of the claim is not what he's being asked to testify to. He's being asked to testify basically as to appropriate insurance practices under the statute. I don't put a lot of stock in the whole thing about the statute versus the contract, but what expertise did he have in the area of insurance practices? I mean, that's their argument.
All right, Mr. Hook testified that during his 25 years representing insurance companies doing insurance defense work in both PI and uninsured motorist cases, he was called upon to evaluate claims, and he was called upon by the insurance companies to evaluate the claims. Mr. Hook, what should we do here? And you know, the argument made, well, he never handled a bad faith case. Well, one of his jobs, and this is in his testimony, was to keep the insurance from committing bad faith, and by giving them the proper advice. And he also gave them advice on how to respond to civil remedy notices, which is the document that initiates the bad faith case. And that's in addition to his experience.
Well, counsel, beyond his specific qualifications, one of the concerns I have, and even with the view of the abuse of discretion standard, is in a bad faith action, should an expert, is it proper for an expert to testify as to the ultimate issue of whether the insurance company acted in bad faith?
Mr. Hook did not use that word. He never testified to that term.
So as long as he doesn't use those precise words.
No, he said they violated the statute, but it's not like he said, I believe they're guilty of bad faith. He didn't say that. Yes, and let me, several reasons why I think that's permissible. First of all, and I know this isn't authority for anything, it's always been the practice before and after Delaware in Florida for attorneys to testify as expert witnesses in insurance bad faith cases. It's just always been the case. And admittedly, there are a few federal district judges that have said no, but one thing Safeco has not done, they have not cited one state court decision, either appellate or trial court order, where an attorney was excluded from testifying as an expert in a bad faith case, because it's done every day. That's the first comment I would make. The second comment I would make is, you know, the argument is made that the testimony is not helpful. It doesn't assist the trier of fact, and I respectfully disagree. The big issue was whether the insurance company's evaluation of the claim was correct or done in good faith. And how in the world is a jury of ordinary citizens supposed to know what goes into it?
And I think you make a good point, but I think there's a distinction between an attorney, for instance, saying I had 10 years of counseling clients on bad faith claims, and under these 5 factual scenarios, you know, that the courts found that amounted to bad faith. And then here, applying those cases to this bag, we find that this insurance company acted in bad faith. And again, making that ultimate legal conclusion, is that proper?
Yeah, so first of all, there's no problem in Florida about an expert testifying about the ultimate issue of the case, as long as it assists the jury. That goes back to the Grounds case back in the 70s from this court. I realize that O'Hare wasn't in effect then, but the issue in Grounds was whether the attorney's testimony in that case violated the so-called rule against testifying to the ultimate fact of the case, and the court said no. As long as, the jury doesn't have to believe it, and that's still the case today. And now it's been codified into Section 90.703, where the witness can testify as to the ultimate fact issue. And that case, that statute's been followed by this court on many occasions. And the bottom line is, as long as it assists the trier of fact, you're really not telling the jury what to do. Now, a witness can't get up there and say, well, I saw the two cars in the intersection, and I believe the defendant was negligent. Well, that's different. That's a different situation. But a jury knows whose fault it was. They can understand in an automobile accident with their own common understanding, but not in this case. Mr. Hook had to explain the difference, for example, between economic and non-economic damages, the permanent injury threshold requirement. All of those things are not within the common understanding of ordinary jurors. But Mr. Hook went beyond that. He explained the civil remedy notice process, which is something else that's foreign to the jury. He explained, for example, there was a default entered against Safeco early on in the litigation, and he had to explain how that affected their duties. So you had all of those factors. And if it wasn't helpful to have an attorney give an opinion, why did the defense put on an attorney witness themselves? We didn't object to it. Now, they'll argue he was better qualified, but that's beauty's in the eyes of the beholder. So the bottom line is this is done all the time. It is not an abuse of discretion to allow an attorney to testify or give an opinion in a bad faith case. I see that my time has expired, and I would ask the court to affirm.
Thank you, counsel.
Your Honors, I think you can probably solve virtually all of these procedural problems that we're dealing with in these cases by following the principle established in Harvey. In Harvey, the fourth DCA said, we really don't think we did the best thing when years ago we said you can bring a bad faith claim together with the underlying third-party claim. It has created a myriad of problems. It has created procedural nightmares. And the only possible benefit is saving a filing fee and service fee. So we are declaring that you can no longer bring a bad faith claim with the underlying tort claim. And to my understanding, in third-party cases, it has virtually eliminated all of these procedural issues that we're dealing with here in this UN claim. And that's within the power of this court to do, is to hand down a pronouncement of that effect. And if that happens, all of this goes away. Because then we simply handle the UN claim to conclusion and the bad faith claim starts, which is how it should be. There is no other area of the law that I'm familiar with where any party is allowed to bring a claim that they know doesn't exist the day they bring it, and then say, well, we know we weren't permitted to do this, Judge, but let's just ignore that, abate this for me. I have a procedural reason for doing this. And all it's done is create a raft of litigation. So we would ask that the court reverse what the trial court did here, and that the court ruled that judgment should have been entered and the UN claim declared over. Now I'll move quickly to Mr. Hook. Mr. Hook's testimony went far beyond just testifying to issues regarding value. Mr. Hook instructed the jury on the operation of 624.155, the Florida bad faith statute, despite having virtually no experience with it. He tried to instruct the jury on what was and was not bad faith law and good and bad faith claims handling practices, despite the fact that there was no evidence that Mr. Hook had ever been involved in advising insurance companies internally or otherwise about what good faith and bad faith claims handling practices were. Again, the gentleman may have a lot of experience in defending personal injury claims, But to try to equate a personal injury claim to a bad faith claim is simply incorrect. They are completely different beasts. They have completely different principles. There's completely different law. And in point of fact, Mr. Hook actually testified in his deposition that a fiduciary duty exists between an insurance company and its insurer in a first-party claim. That's absolutely wrong. There is no fiduciary duty. It's an adversarial relationship. Mr. Hook, when asked on the witness stand by me, the names of the most basic bad faith cases in the state of Florida, the stuff that I assure you that any lawyer practicing in this state could repeat off the top of his head, couldn't tell you the name of a single one, didn't know it. So again, we suggest that Mr. Hook was not properly presented as a witness and that the case should be reversed on my grounds.
Thank you, Counsel.